evening to everybody, and hello and welcome to our New South Wales Small Business Month webinar series on HR Essentials for Regional Small Business. My name's Bronwyn Pearson. I'm the CEO of Pinnacle People Solutions. I have over 25 years experience providing the full range of HR support and advice to regional employers of all sizes. And it's been a privilege to enhance regional communities by supporting local businesses across our wonderful states in Australia. At 5:30 each Wednesday afternoon during the month of October, we will be looking at 4 topics to refresh ourselves on the HR basics. Contracts and position descriptions this evening, record keeping obligations next week, paying staff correctly the week after that, and the final in our series will be on policy and procedures. All of these videos will remain on our Facebook page and our website, along with accompanying fact sheets, so you can come back and review them anytime and also take information away that will hopefully be of benefit and help to you. So tonight we'll be looking at employment contracts and position descriptions. Now, and good evening to those who have already said hello on our chat screen. Don't hesitate as I go through this evening to ask me any questions that you might have as we go along. If there's anything that I need to take on notice, I'll do that and I'll come back to you. If you just can private message us your direct contact details, so we can do that. Otherwise, I should be able to answer most things that you might have for us in the chat screen. So tonight, as I said, we'll be looking at employment contracts and position descriptions. And look, here's the thing. By law, you are required to provide details to your staff about their terms and conditions of employment, their pay, and their duties and responsibilities, and to keep associated records, which is going to be the subject of our tonight and our upcoming webinars on HR for Business Basics. During the month of October, which we are celebrating, of course, being Small Business Month. Here's the thing. There's an obligation. You are required to provide your staff by law with a whole series of information about their role, your organisation, the award they might be covered under if they're covered under a modern award. There's a whole range of information that you must provide to your staff in writing when they start with you. And that is one of your many record-keeping obligations that we'll be talking about further next week. There is, in fact, in Australia, no obligation at law, so no legal obligation to have a written contract of employment so much. So you may be wondering, why should I have one at all? Well, we would argue that given that you're obligated to provide a whole heap of details to your staff in writing, as employment law requires you to do, why not go one step further and make sure that all of that information is in the form of a written contract of employment? So a written employment contract is designed to protect you as the employer, because without something in writing, disputes can arise over terms and conditions of employment. And unfortunately, I've seen this happen many, many times. And in every case, it could have been avoided by having clear written terms and conditions of employment that are not open to ambiguity, or he said, or she said, or any of the variations in between. My experience is that employers may run into difficulties dealing with their employees where there are no written employment contracts in place to guide the employment relationship, or indeed when they're ending an employment relationship. So, for example, if an employee moves to a competitor without having any post-employment obligations or any restraint clauses in their employment contract, or indeed any contract in place at all, that is one of the most common situations that we're asked to provide advice and support with. And it's particularly significant, can I say, in rural and regional areas, because, you know, those kinds of situations can arise perhaps more regularly than they can do in a metropolitan area. So an employment contract at its very sort of basics is an agreement between an employer and an employee that sets out terms and conditions of employment. There also may be no evidence of the agreed terms and conditions of employment without a written employment contract. So that can be the case very much if you've got a staff member who's not covered by a modern award, so therefore doesn't have another instrument that has terms and conditions that would be defaulted to, and perhaps might only default to the Fair Work Act, for example, as a staff member employed under the federal system of employment law. So we need to be really clear: who is the employer? What is the commencement date? What are the agreed hours of work? Where will the work be performed? Who does the employee report to? What is the agreed remuneration for the employee? How much notice does the employee have to give you, for example, as the employer, if they want to resign, or indeed that you need to give them if you decide that you want to terminate their employment? These are all basic questions that are very easily answered by having a written employment contract in place from the start. So the written contract should include, but let me be really clear, while I'm giving you a list of inclusions, it's not limited to these. So every employment contract needs to be fit for purpose for the role and the organisation and the duties and responsibilities, etc., bearing in mind those compliance obligations that every employer has under employment law to provide in writing a whole range of information about somebody's employment that you're obligated by law to do in any case, whether it's in the form of a written employment contract or not. So back to what a written contract should include, but again isn't limited to: the nature and the status of the employment. So is it full-time? Is it part-time? Is it fixed-term contract? Is it casual? The award that the employee is covered under, if indeed the employee is covered by an award. So back in 2010, following the introduction of the Fair Work Act in 2009, we had what was called the award modernisation process, and that led to the consolidation of hundreds of awards into, last count, I think it's 122 modern awards. But it might surprise you that even with that number in play, that not everybody's duties and responsibilities actually are covered by a modern award. And if that's the case, then the terms and conditions of employment for somebody would default to those that are in the Fair Work Act and the accompanying national employment standards, and then any additional terms and conditions that you might have in somebody's employment contract. Another reason why the employment contract is very important. You would also want to have in an employment contract the person's commencement date, the details of you as the employer, including your ABN, the employee's name and the position title of the role that they're going to be doing for you, any detail on probationary or qualifying periods, the location of their employment, their hours of work, their remuneration, return of property, so instructions on what's to happen in respect of returning company property at the end of the employment relationship, deductions, so how deductions will be managed from pay and how deductions would be managed from a final pay in the event that there is a debt of any description to the business. Confidential information, so that's making sure that employees are very clearly provided information about the requirement to keep all information they come across during their employment with you confidential until death. So that confidentiality obligation should be in an employment contract and should continue until the person continues, essentially, and goes beyond the employment relationship. It should also refer to the requirement for a staff member to comply with the company's policies and procedures, details around superannuation, and details around period of notice and termination. So one of the most, and as I said, those details are at minimum, certainly not limited to those, and there would be other clauses that we would advocate, like intellectual property, like a drugs and alcohol clause, like a workplace surveillance clause. There are a range of others that we would also recommend in most instances. But we'd be very happy to talk to you about what employment contracts should comprise relative to your organisation, the kind of role, and the nature of the engagement with the person. So let's look at some of the most common questions that we get in respect of employment contracts. So the first one, one of the most frequent questions we get is, do casuals need employment contracts? The answer to that is a very resounding, in capitals, yes. Employment law is developing all the time. This year is a classic example for that. The changes that have come in temporarily around the response to the COVID pandemic, some of the case law that's come down this year, interpreting the employment legislation has been really quite significant. So employment law is developing all the time. And it's really important to ensure that you're up to date at any particular point in time. There's been a recent case called the WorkPack case. In fact, this is the second case involving WorkPack actually in the last 18 months that has required an extra clause for casual contracts to prevent casual employees who later decide that they believe that they have actually been permanent employees from being able to claim both the 25% casual loading and permanent leave entitlements such as annual leave. So if the employee turns out to be a permanent employee at some point in the future, or is deemed to be so, and seeks to be paid permanent entitlements, then they will have to pay back the casual loading. So they don't get both, which is this issue of double dipping that has come through in these case laws. So what we've done, for example, as soon as that decision came in, was that we sought to update all of our casual employment contracts for our clients to make sure that those clauses were very, very clear in response to that case law interpretation. So one of the other questions that we often get is, what if I get a contract wrong? Here's the thing. You as the employer may not be able to rely on the terms of the contract if it's wrong, or worse, having a written contract if the wrong contract is chosen could actually put your business at risk. So for example, if the business engages an employee on rolling fixed term contracts for, let's say, a set period of time, for example, 2 years followed by another 2 years followed by another 2 years as an example, the employee may have the same entitlements as an employee on a conventional ongoing permanent contract. For example, they may be entitled to exercise unfair dismissal rights and the entitlements to redundancy. So it's incredibly important, to have employment contracts in place, but also that they are correct and entirely fit for purpose for the staff member, the position, and the organisation. So one of the other questions that we get in terms of the accuracy of employment contracts, etc., is when would you need to update an employment contract? So let's say, for example, there's been a change in hours, a change in salary, a change in role, or a change of type of employment. If it's a small pay rise or a change in hours, but the position itself remains unchanged, there is no need for a complete new employment contract. You could provide a letter stating the small change, but also noting that the terms and conditions of the employment contract otherwise remain unchanged, which is what we would call a variation to the employment contract letter. So it's not having to issue a whole brand new one. It's doing a variation, but a variation will depend on what elements of the employment contract are going to be varied and whether a variation letter is sufficient or whether there is a need for a new employment contract. So for larger changes, such as moving from part-time to full-time, for example, full-time to casual, promotions to a more senior position, a different position than the one that the employment contract refers to, larger pay increases, you should provide a new contract of employment. Okay, so one of the other questions we often get is, what's the relationship between an individual flexibility agreement and an employment contract? And can a business incorporate an individual flexibility agreement into their contract of employment? And the answer to that is yes, you can include an individual flexibility agreement to accompany the contract of employment. So flexibility provisions within modern awards allow employers and an individual employee to enter into an arrangement whereby certain terms of the award are modified to meet the individual circumstances of that particular employment relationship. And those flexibility provisions mean that if you're going to enter into that kind of an agreement with a staff member, you need to identify the terms of the award which you wish to vary, and what the effect of that variation is going to be. Once you do that, the flexibility agreement will need to identify with sufficient detail how the effect of that particular award term is being modified by the flexibility agreement. So for example, it will be necessary to show that a particular entitlement has been removed, altered, or even increased. In addition to that, you need to make sure that any flexibility agreement results in the employee's terms and conditions of employment being what's called better off overall than if the flexibility agreement didn't apply. And that's what we often call the BOOT test, the better off overall test. So if you have a flexibility agreement in place, or you come to an arrangement with a staff member, which then does need to be documented in an individual flexibility agreement, otherwise it can be challenged. And we've seen that happen numerous times. So it really is important to get these things in writing. It is very important to be able to demonstrate that the flexibility agreement provides conditions that mean that the staff member is better off overall. So that means that you must ensure that that individual flexibility agreement identifies in sufficient detail how the agreement ensures that the staff member is better off overall as compared to the award. So let me give you an example. It will be necessary to show what benefits or entitlements an employee will receive, such as an increase to their wage, for entering into the flexibility agreement. One of the reasons why you might want to keep individual flexibility arrangements separate, however, to an employment contract is because individual flexibility arrangements can be changed or terminated by either party giving 13 weeks notice. So if you make it a separate document to the employment contract, that can be varied with the appropriate notice without having to redo an employment contract. If they are inextricably linked, you will need to update the employment contract as well. Okay, so I'm just looking in my chat screen, and at the moment I don't have any questions about employment contracts, but I'd be very happy for you to ask any questions about that, or position descriptions, or anything else that might come into your head as a consequence of the topic we're talking about this evening. Don't hesitate, pop the questions in the chat screen and I'll keep an eye on it as I am and answer those as they come in. So in terms of position descriptions, one of the things, as I mentioned at the outset, that employers are required by employment law to do is to make sure that there's each of their staff members, irrespective of the nature of their engagement, so whether they're permanent full-time, permanent part-time, fixed term or casual, is that they need to be given a very clear list of duties and responsibilities for their job. And we would advocate that the best practice around doing that is to have a position description. So a position description, and again, I'm not talking about a war and peace. I'm talking about 1 or 2 pages at the most. And that document ensures that both parties, so the employer and the employee, understand very clearly what the duties of the position are. It's a really good idea to include a clause in the employment contract that allows you as the employer to change the duties of the position or ask the employee to conduct other duties that could be reasonably asked of them. And by reasonable, we mean duties that they could be reasonably skilled and experienced to be able to perform. That way, you don't have to list every duty in a position description, and the position description is merely a guideline. So you can actually make amendments because we know that duties and responsibilities do shift over time. It's important to keep up with that. If your staff member is covered by a modern award, a good starting place is to use the classification and job descriptions from the appropriate award as a starting tool. Position descriptions can, and in most cases should, also be drafted in consultation with an employee. Although if it's a position that you're recruiting to, I would think you would develop a position description as part of the documents that you give any keen applicants for your business, so that they're really clear about what position they're applying for. One of the other areas that I want to cover this evening that is incredibly important for business owners to be aware of as well are independent contractor agreements. And some of you might have heard the term sham contracting, and situations where employers, either through ignorance or maybe not so much ignorance than trying to do something that's a little bit dodgy, like evade their employment law obligations to a staff member, can actually say to somebody, "Oh, as long as you've got an ABN, just invoice me, and we can do it we can pay you as a contractor." Yeah, it's not that simple. So one of the things I want to talk to you about this evening while we're talking about employment contracts and position descriptions is independent contractor agreements. So an independent contractor, a genuine independent contractor, is a person, so for example, the sole trader or a partnership or an entity, so for example, a corporation, a PTY Ltd company, conducting a business or an undertaking. An independent contractor will be engaged to perform work under a contract for service. So they're not people that we're talking about here. We're actually talking about this organisation contracting services from this organisation. They don't have the legal status, independent contractors that is, of an employee, and they're engaged by a principal as opposed to being employed by an employer. So independent contractors are generally responsible as a consequence for their own taxation, superannuation, and a whole raft of insurances that you would need as a business owner to make sure were in place before you engaged anybody as a genuine independent contractor. But I do need to emphasise here that term I made before, sham contracting, because take note, we have seen many cases of sham contracting, which is why we've got significant amounts of case law now around how it will be interpreted. And this is when an employer deliberately disguises what would otherwise be an employment relationship as an independent contracting arrangement instead of engaging the worker as an employee, thereby not paying workers' comp, not paying their superannuation, leave, all of those sorts of things. This is usually done in a deliberate way to avoid paying employment entitlements, as I said, like superannuation, workers' comp, leave, and certain taxes. But it can actually be done, as is often the case in my experience with regionally based small to medium enterprises, and that is purely out of ignorance. The employer does not understand what their employment obligations are once they engage their first staff member, and consequently, they're not aware and therefore do the wrong thing inadvertently rather than deliberately. Unfortunately, employment law doesn't give any of us as employers a hall pass for ignorance. So we're going to get fined and we're going to have sanctions if we breach the law, irrespective of whether we were motivated to do so deliberately or not. So one of the reasons why we wanted to do this Back to Basics series this month for celebration of Small Business Month is because it really is important for all employers to get back to basics and really get familiar again, if perhaps for the first time, on what their employment law obligations are whenever they have a staff member. Okay, so let's look then at some of the practical realities coming out of the discussion today around employment contracts, position descriptions, the need for independent contractor agreements if you're going to have a genuine independent contractor whose services you're of a business that you're engaging. You need, and it's really important as a small business, to protect your business by making sure that you have robust employment contracts and position descriptions and really good policy in place, and follow the steps. Make sure entitlements and obligations are crystal clear. Establish clear expectations through well-ordered, well-worded position descriptions, so you don't leave any room there for ambiguity. So that is the end of the substance of today's discussion around employment contracts, position descriptions, and independent contractors. I haven't had any questions in the chat screen yet, but I would encourage you, if you do have any questions for us, or if there's anything that we could do to support you, you can certainly get in touch with us for a no obligation free conversation about where your business is at and the questions that you have. We'd be more than happy to help you. And we are delighted to be partnering with the New South Wales Government this month to offer these free webinars every week for the month of October, getting back to business basics. So thank you so much for joining us today. If you have any questions or you'd like to talk to us individually, you can, of course, always email us or phone us, private message us. If you're on Facebook, we'd be very happy to talk with you and to help you in any way. Thank you so much for joining us today. We're delighted to have you with us. Our contact details, my lovely team have popped up in there in the chat screen. So any of those means will get to us, and we'll be happy to to talk with you. You can also register for our other webinars this month for Small Business Month, and our wonderful team have just put up the link there in the chat screen for you so that you won't miss any of the Back to Business Basics series. We will also be producing a fact sheet, which will go up on our website and be available very shortly after this evening's webinar. And here's the other thing: if you've got fellow colleagues, business owners, staff, etc., who you'd really like to share this with, you can absolutely do that. So we have a lovely archive, including this suite that we're going to be running in October, up on our website, on our YouTube channel, here in Facebook, all of the different platforms, whichever one you prefer to use, you can find that information. All of them also have fact sheets attached to them. So please feel free to like and share this information so that we can make sure all of our small business owners, managers, employees, colleagues can get access to the information they need to know that they're doing business well. My experience is that small business owners tend to get woken up at 3 a.m. in the morning by two things: worries about money and worries about people. So we can help you with the people side, and often that also helps with the money side. So we'd be delighted to talk with you. In the meantime, thank you so much for joining us. We really look forward to seeing you again 5:30 next Wednesday, when I'll be talking about record keeping as part of our Back to Business Basics for Small Business Month in partnership with the New South Wales Government. Thank you so much again for joining us this evening, and we'll look forward to seeing you next week. Bye-bye.